I'm Anita Barber, and I practice in Orlando, Florida. And one of my most enjoyable planning experiences has been when I worked with the owners of a very successful franchise business. Mom and Dad owned a company, and after years of being in the company, had decided that they were ready to sell the company. And they engaged an investment banking firm to procure an appropriate buyer for them, and in the beginning of that process realized that they need to also address their estate planning with this sale. They engaged my firm to review their current estate plan, to review the sales transaction, and the impact that that sales transaction was going to have upon their estate plan. Well, the challenge we had here is a very traditional challenge. Very large estate values with large estate taxes. A good problem to have. And then also another challenge with us at this was that Dad was not in good health. So what we did as our solution is that we implemented a multi-step family transaction prior to the sale of the company. We had Mom and Dad recapitalize the company and have the company then go into voting and non-voting shares. We also had Mom transfer some of her shares to Dad and overweighted Dad's ownership in the company. After that, we then engaged Mom and Dad into a part sale, part gift transaction where Mom and Dad gifted some shares to each of their 5 children and also sold some of their shares to each of their 5 children. The children gave back Mom and Dad skins, self-canceling installment notes. And as you may remember, I had said earlier that Dad was not in great health. He was in a bit of a poor health. So at this stage with the skin and his health, we had another challenge, and we did need to obtain a certificate from his physician regarding the health of his health and the probability of it being greater than 50% that he would live greater than 18 months. So obtaining that certificate from Mom and Dad, we were able to complete the family structure, which resulted in Mom, Dad, and the 5 children owning the shares of the company. Thereafter, the company was sold, and the proceeds of the shares the proceeds of the sale were distributed to the children and Mom and Dad. The children used the proceeds to fund their note payment. So we had to make sure through the sale and everything that it was such that the cash flow worked, and it did. So for that time that after the sale, the proceeds were used to fund the note payment. Later, when Dad did pass away, because of the use of the skin, millions of dollars of assets were not included in his estate, which resulted in savings of millions of estate taxes. Also at that time, Dad had some unused exemption. Mom, as a surviving spouse who was beneficiary under the trust, disclaimed further assets that also went down to the children. With the assets now in the hands of the children and the enhanced savings from the estate tax, more assets into the hands of the children, the family was actually able to engage in faith-based planning, that they had faith-based initiatives in the community that they had not been able to do previously, and that had been one of their desires in this whole transaction. My more than decade membership of WealthCounsel, attending the various WealthCounsel courses, and also just the collegiality of the WealthCounsel members have really enhanced my experience and has helped me bring these more sophisticated planning solutions to my clients.